Welcome to the students from Kentucky. The judges will introduce themselves. I'm Edward Volpe. I'm an attorney in Denver, Colorado, and my colleagues are.
Hi, I'm Caitlin Johnston. I am an attorney in New York City and a We the People alum. I did it when I was in Indiana in high school, so good luck.
And hi, I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and congratulations on being at the Nationals.
And I will ask the students to introduce themselves in the order in which they will be presenting.
Hello, I'm Laura Winkler.
Hello, I'm Karina Mills.
Hi, I am Jacob Daly.
Hello, I'm Ellie Rowland, and we represent Highlands High School and the Commonwealth of Kentucky.
Welcome to you all. As you are presumably aware, your question today is question 1, and I will read it to you. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of this decision? Why or why not? What words, if any, are found in the United States Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? You may begin.
Throughout the Reformation, the fight for political power between Catholics and Protestants caused many to flee to the colonies. During the creation of the Constitution, framers ensured that religious persecution wouldn't reoccur by stating in the First Amendment that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof.
Article 26 of the Universal Declaration of Human Rights declared that parents have a prior right to choose the kind of education that shall be given to their children. Therefore, we agree with Wisconsin v. Yoder. The Free Exercise Clause allows for free religious practice as long as it does not harm the public's general welfare and does not undermine laws that apply to all.
In the case of Lakimi Babaloo A. Incorporated versus the City of Hialeah, it was held that the City of Hialeah's ordinance prohibiting ritual animal sacrifice violates the First Amendment's Free Exercise Clause. It established that religious beliefs need not be acceptable, logical, consistent, or comprehensible to others in order to merit First Amendment protection. The ruling of Wisconsin v. Yoder aligns with this case by solidifying the importance of maintaining religious freedoms for all without harming the public.
However, the courts often ruled against religious beliefs when established laws were broken. In Reynolds v. U.S., the courts ruled people cannot avoid a law and cannot partake in polygamy due to their religious beliefs. This was furthered by Employment v. Division Smith, when the courts ruled a state couldn't deny unemployment benefits for a person fired for violating a state prohibition of the hallucinogenic drug peyote, even though it was used for religious purposes. These cases ruled against the Free Exercise Clause due to the fact that they caused harm to the individual and general public. Furthermore, allowing exceptions to every law affecting religion would open exemptions to almost all civic obligations, such as military service, tax payments, and childcare.
Although we agree with the result of Wisconsin v. Yoder, we recognize the ramifications it poses towards a child's educational opportunities as brought to attention by the Amish Heritage Foundation, who advocate to overturn the case. Prince v. Massachusetts held that the government has the broad authority to regulate the actions and treatment of children. In Wisconsin v. Yoder, there is no protection to a minor's right to an education since the parents can decide the minor's future without considering the child's desires, as argued by Justice Douglas's dissent, in which he stated that children themselves have constitutionally protectable interests.
Education is not explicitly stated in the U.S. Constitution, as founders desired to leave the powers not delegated to the federal government to be determined by the states, as established by the 10th Amendment. The case of San Antonio Independent School District v. Rodriguez declared that education is not protected under the Constitution. However, the Equal Education Opportunities Act of 1974 requires states to provide non-discriminatory educational opportunities for all. In the case of Plyer v. Doe, the court held that if a state chooses to provide educations to citizens, it must also offer it to the children of illegal aliens, upholding the Equal Protection Clause.
States are responsible for the maintenance and operation of public schools. While some state constitutions include lengthy educational provisions that detail explicit requirements for local school systems. Others simply identify the need for an education system. The Kentucky Constitution broadly states, the General Assembly shall, by appropriate legislation, provide for an efficient system of common schools throughout the state. Conversely, the New Mexico Constitution includes specific details about the uniform maintenance of schools, such as teaching in both English and Spanish and catering to disabilities.
The freedom of religion is explicitly established in the Constitution, but education is an inferred right not guaranteed to individuals. Therefore, the prioritization of free religious exercise in the decision of Wisconsin v. Yoder is constitutionally sound. As written by Chief Justice Berger, however strong the state's interest in universal compulsory education, it is by no means absolute to the exclusion or subordination of all other interests. Thank you, and we're now ready for your questions.
What tests should be applied to an analysis of laws that impact religious beliefs? What existing tests have been recognized?
In the case, go ahead, Ellie.
We see the Lemon test being applied after the decision in Lemon v. Kurtzman to test laws and determine whether there is an excessive entanglement between religion and education and government.
The Lemon test also includes that the government should not pass laws that are overly biased to one religion or another, and this ensures that the Establishment Clause is upheld.
And as my colleague said, as we see in the Free Establishment Clause and many other acts and laws, not just tests, there's many regulations for education and making a free public non-denominational education, especially with the Free Exercise Clause, as it holds that the U.S. government does not make kind of push people towards a specific religion, which is very important in the regulation of it.
So I'd like to talk a little bit about how we should be weighing a parent's religious beliefs against the rights of the child. And I'd like to throw a hypothetical at you. How should we analyze a religious sect that compels young girls to marry and bear children before they've reached the age of 18?
I believe that a minimum amount of education should be required. However, we see that states such as Virginia's Article 8 in their state constitution requires no education at all. And I believe that having a foundation of education will give those children more opportunity to make their own decisions for their life.
Furthermore, considering the hypothetical that you proposed, it is in the job of the courts to establish if that individual youth has the ability to make their own decision. So if they are too young to make that decision, that is something that could potentially cause harm to them. So it would be a decision that they could not marry a legal adult, while and in the terms of education, these parents' decisions aren't going to cause physical harm, and it has to be reassured that in especially the Amish faith, these students do not terminate their learning. They continue to learn in areas of their belief, including household tasks and farming and things that they are going to use on an everyday basis. So that is the basis that this court ruling was made upon, is that their learning does not end, but it ends in the traditional public school that we look at, not in their faith.
Sure, but I want to talk about bodily integrity, not the right to an education. What do you have to say about that?
I think we can compare this to the decision in Reynolds v. US, where it was decided that even though the religious beliefs of the Mormon faith allowed for polygamy, since this harmed the general welfare, it was declared that polygamy was unconstitutional and illegal because it harmed the general welfare, even though it was part of the religious faith.
As we referenced in our opening statement, the case of Prince v. Massachusetts deals with blood infusions and how the children can decide that and the parents have no say. And so we could farther this case to connect to minor marriages as well.
Do you think that the children should have their concerns or issues addressed under a Yoder analysis? Do they play any role in a determination about what is in their best interest?
Wisconsin v. Yoder is ruled that the children do not have a say and that the parents have full consent over whether or not their child can go to school. And so I believe that the children should have more say, and that in the court cases, the children should be able to determine what their future wants to look like without their parents' full consent.
And obviously,
Go ahead.
and kind of a big part of that causes, parents to be able to make these decisions for kids is, as we see in Article 26, it kind of trumps almost the Prince v. Massachusetts, where the government can make decisions for kids as well, but also with Article 26, you can also see it gives the parents the right to make decisions for kids as well. So it kind of, there can be a big gray area between who can make what decision, which definitely can cause problems. And as my colleague said, I think we're all on the same page that we kind of believe that kids should be able to make more of their own decision, especially as you get older and mature more. Kids have their personal interests that possibly conflict with parents, and that's something that they should be able to make that choice themselves rather than somebody else controlling it.
We aligned the decision of Wisconsin v. Yoder with a common practice done in the United States, which is parents have the choice to enroll their children in public education or in private education or in a religious education. So we kind of connected it to a lot of children without their say are being enrolled into a Catholic education. And this, although they don't have a choice in that, they are still receiving an education that their parents see fit. So in the terms of Wisconsin v. Yoder, the parents are pulling their children out of education to pursue an education, a religious education that they see fit for their religious belief and practices.
Could a school and/or any governmental entity require that people of a particular, or students of a particular faith, go to their religious schools as opposed to public schools?
Are you talking in regard to a religion requiring that they go to a specific school?
Well, I'm saying that if the school district and/or any governmental entity feels like the religion is interfering with their ability to conduct the public schooling, could they force the religious students of that faith to go to their religious school as opposed to the public school?
I believe under the 14th Amendment, it states that the government is not allowed to discriminate, especially with the Free Establishment Clause. The government is not able to discriminate against any race, religion, or personal beliefs, and so on. So that would be a direct violation of that right there.
Furthermore, going off what Jake said, the case of Pierce v. Society of Sisters ruled that no one education, whether religious or public, is better than the other, and the government cannot force students to attend one or the other, and that they have their free will to choose.
Furthermore, we see in state constitutions that they have certain clauses that determine that the state must provide free public education for all students.
Can a school require students to be vaccinated over religious objections?
They cannot, and it can be seen, it's a controversy currently because of the COVID vaccine, but each school, at least public schools, have the opportunity to.
Can they finish their sentence?
Yeah,
I think
finish
so.
your sentence.
Yes, please.
Parents have the ability to sign specific legal documents that exempt their children from vaccinations. And that, like I said, has recently come to light in terms of the COVID vaccine on will children be required to become vaccinated for education, and will individuals be required to be vaccinated to travel?
Very well done. I congratulate you all on your very hard work and the degree to which you developed an understanding of these terribly complex legal principles. I was impressed by what you were able to tell us, not only with respect to the Wisconsin v. Yoder case, but with regard to a variety of other cases. You came up with San Antonio School District versus Rodriguez, which said essentially that education is not guaranteed by the federal constitution, but you went on to point out that almost every state constitution addresses public education and provides for the funding thereof. In response to my first question, you did come up with the Lemon versus Kurtzman case, which sets forth 3 different tests for the impact of laws that impact religion. Then late in the presentation, Laura came up with Pierce versus Society of Sisters, which said that if a religious student wants to go to a religious school, the governing authorities cannot compel them to go to a public school. And I thought that was a very interesting presentation. You did say that the school cannot compel vaccinations. I think that is an extremely pertinent point for today's world, but I would alert you to the fact that the Supreme Court has upheld required vaccinations in one of their rulings. It's called Zucht, Z-U-C-H-T versus King. The citation to the Reynolds case was very, very pertinent. Obviously, state law banned a practice of the Mormon faith about polygamy. And in the course of that decision, the Supreme Court said the right to an education or the right to religious practices is not absolute. It can be regulated by the state. And you go on to talk about Smith versus Employment Division, about whether private employers are bound by the religious beliefs of their employees, so forth and so on. And you did disagree with Yoder with regard to the impact upon the students themselves, and I thought that was an excellent point. And by and large, you went on to talk about the Kentucky Constitution. And I thought it was very interesting that you came up with the Church of Lukumi Babalui versus City of Hialeah, which talked about the religious practice of slaughtering and cooking and consuming animals in the course of a religious ceremony. But it was upheld that the city of Hialeah could not prohibit the banishment of that slaughter of animals. Now, it was pertinent that, as the court noted, that just down the street from the church, there was a chicken processing plant, which processed chickens for sale across the country. So it was a disfavorable impact upon the particular religion of trying to ban a practice that was widely allowed in other aspects of society. But the fact that you came up with that case was very, very impressive. That's enough for me for this, other than to say, again, I was very impressed by your presentation. I'll turn it over to my fellow judges.
Yeah, I agree. Great job. I too loved the examples where you were kind of teasing out the differences where the courts come down, in favor of protecting religious rights and where they've drawn the line. I was trying to extend that discussion in my follow-up question. My only feedback for you would be make sure you listen very carefully to the hypothetical, because I think y'all jumped in wanting to talk about education, and that's fine, but then you've got to pull it through to what I was going after. And after a couple rounds, after I pressed you got back to some of the other cases that you had mentioned where as Mr. Volpe said, that it's the right to religious beliefs are not absolute, right? And I could sense as we spent more time talking together that you got more comfortable with your follow-ups, because towards the end of our discussion, you were pulling out more case citations than we started off. So maybe that was just nerves. But I overall thought it was a good job, and I enjoyed the discussion.
I don't have a whole lot more to add. I would just echo what the other judges have said. Very well done. I was writing down cases that you had touched upon during your presentation, and then also in some of the follow-up, and it's quite an impressive list. You did reach and address a number of the pertinent cases that are addressing this area. It was it's always interesting because the Yoder case is a very it's a challenging case, because most people seem to agree with Justice Douglas' dissent and some of the comments that the majority says we're not addressing the issue or the beliefs of the child at this point, because that's not before us. But everybody seems to think that's really a very important and pertinent thing to know, and what is the child's position. But that's not what was in front of the court in Yoder. And so your position that you agree with the decision, but then kind of teasing out that, well, you really would think that it'd be better if the child's beliefs or position was addressed, I think is an important one. So I would also agree with Judge Johnson as far as listening to the questions to make sure you understand them. Her question about the marriage and of the underage it generated initially some discussion about the school issue, and you did get around to the topic, and that was very good. But well done, very well done. You should be proud of yourselves, appreciative of your teacher, and your teacher should be proud of you as well. So thank you for your presentation.
Thank you.
Thank you.
Yeah.